And Dorothy Williams.
Hello, sir.
Hello.
How are you?
I don't know yet. You're gonna.
We are jumping straight into a landlord-tenant showdown that is about way more than just numbers on a ledger. Arbor Woods says nearly $2,000 is owed. Elia Reeves says she paid every single cent. And sitting in the middle of it all is Judge Simpson, trying to separate emotion from evidence. This isn't just a routine eviction hearing. It's a case built on missing money orders, management turnover, and a 94-year-old mother whose housing security is on the line. Right away, you can feel the tension. The judge tries to lighten the mood, but the defendant is already bracing for impact. That tells you everything. She believes she's being accused unfairly. And when someone walks into court convinced they've done everything right, but they're still being sued, emotions explode fast. Here's the twist. This isn't a simple "you didn't pay" case. It's a "we paid, but someone cashed the money orders" case. That's a legal nightmare. Because in landlord-tenant law, what matters is not just intent to pay, it's whether the landlord actually received the funds. So buckle up. We're about to watch a collision between receipts, responsibility, and raw frustration.
Well, I don't know, because you look like you're gonna yell at me.
No, I'm not. My mother told me to calm down before I have a stroke.
And she said, calm down when you come before me, didn't she? I like your mother.
Hello, sir.
Hello.
How are you?
I'm doing just lovely. Thank you for asking. How are you? All right. And also Dorothy Williams. All right. So last time we were here, there was 1,066.69. How much is owing at this point?
Your and I rents to retain of $856.64. Cost of $240 for a total of $1,096.64.
Yeah, went up a little bit. All right. How are we going to get this paid off?
It's already paid, sir. They lost it.
Okay.
They lost my rent.
Hold on.
That line changes the energy of the room instantly. They lost my rent. This is no longer about inability to pay. It's about alleged mishandling or even fraud. The moment a tenant claims the landlord's office lost or misdirected funds, the case shifts from simple eviction to potential financial misconduct. Notice what she says next. Management quit. Staff turnover. The person who handled the rent is gone. That's critical. In property management disputes, chaotic office transitions can create serious record-keeping gaps. But legally, chaos is not a defense for non-payment. Here's the legal reality. Unless the landlord received and credited the funds, they can still pursue eviction, even if the tenant purchased money orders. That feels harsh, but that's the standard. Now here's the bigger question. If you were in her position, with receipts in hand and a 94-year-old mother at home, would you feel calm? Or would you be exactly this frustrated?
I have receipts. I gave them receipts. She took a photocopy of it.
Who?
The lady that was up there in the rent office. Her name was Dana. We don't have management because everyone has quit. And my rent came up missing, and the woman that was there, she quit or got fired. Now,
All right. Are you going to have your January rent?
Yes.
Okay. When are you going to pay your January rent?
On the 3rd.
Okay. Then here's what I'm going to do. What's your monthly rent?
$657 plus the water bill. My mother is 94 years old.
Yes, I recall, ma'am, the last time you were here.
I'm trying to stay calm, sir, but I am so upset because I have never went without paying the rent. And here these people got me up in here defending myself, and I got receipts, a bag of receipts, a bag.
So you pay your 657 plus whatever your other charges are. You're to pay that by January 3rd, 2020.
Yes.
25. Okay.
Yes, I pay it every
that rent. So this way the number doesn't get worse. So everything is done, and then we can try to figure out where we go from here on this. I'll adjourn this then to January 10th, 2025 at 3 p.m. Hello.
3 p.m.
Okay, at 3 p.m. Okay.
Yes,
And
sir.
we'll figure it out in terms of what was lost and when it was lost and anything along those lines, okay?
Yeah, and can I say something? They told me that I had to run this thing down. I called MoneyGram. MoneyGram said that one money order was cashed on the 7th. Another one was cashed on the 8th. What the heck? What the heck?
This is where emotion overtakes procedure. She's describing MoneyGram confirmations that the money orders were cashed, but not by the intended recipient. One allegedly to Susanna Vera, another altered to a roofing company. That is explosive. If those instruments were altered after issuance, that suggests possible forgery or unauthorized negotiation. That's not just a housing issue, that's potentially criminal conduct. But here's the legal snag. The court today is not a criminal fraud hearing. It's a landlord-tenant possession case. Judge Simpson's job is narrow: determine whether rent was received, not who may have altered documents. That's why he pivots toward documentation, written confirmation, paper trail. Because in court, emotion doesn't win. Evidence does. And think about this. If the payee name was whited out and replaced, how did the financial institution allow it to clear? That's a procedural red flag. Something here does not line up.
Okay.
And then you're going to send me papers talking about find it? You find it. I told them, you lost it, you find it. Doggone their time. I'm not happy. I'm not happy. My mother is 94 years old. She has a colostomy bag on one side and a tube in her gallbladder on the other side. We cannot afford not to pay our rent. She's 94.
Ma'am?
Doggone their time.
Ma'am?
Yes. Yes, sir.
What I need you to do is, if you got confirmation that those were cash,
Mm-hmm.
I need you to get written confirmation from MoneyGram
Mm-hmm.
that that has happened.
Mm-hmm.
Bring that to the next hearing,
Okay.
because that's going to be important for us trying to figure out what happened.
Okay.
Okay?
Okay, sir.
All right.
Happy New Year, Judge
Yes.
Simpson.
Yes, ma'am.
And Happy New Year to everybody. She told
Because the last couple of times.
yeah. Oh, but you know what, Judge Simpson?
Yes, ma'am.
I have so much on my plate and I know what I've done. And when you know what you've done and someone is trying to tell you you didn't do it, I'm like, but here it is. Would you give this to Judge Simpson, please?
Are you just going to do what she says? I know. I was scared. No, I got you. Okay, what am I looking at? ma'am?
You're looking at the receipts that I was telling, the money orders that I bought for the rent for October. And all this time I was telling you, someone up in that office took my money orders.
Okay.
I'm trying
See,
to.
no, right now you're not listening to what
Okay.
your mama told you, right? Right?
Yeah.
Okay. Okay. And you have not shown this to counsel.
No, I didn't show it to anyone, but my mom and you. And you see where it looked like they whited out? You know, Susanna Vera, who is she? Who is she?
Who?
Susanna Vera. If you see on one of those money orders
I do.
that says Susanna Vera, I don't know who she is. And on the other money order, it was made out, crossed everything out, and made out to a roofing company. I don't know nothing about no roofing company. I don't.
So with these money orders, you're saying you put them into.
I put them, I done, if I didn't have time because we don't even know when the office is open anymore. I know, but you know what, sir?
Woosah.
Okay,
Take it down.
okay.
You are not going to make it through this hearing without. If you need to yell at me. I can
No.
take it.
Judge Simpson does something interesting here. He shifts from judge to emotional buffer. He invites her to yell at me. That's strategic. He's diffusing tension to preserve courtroom order. This is a judge who understands that high emotion can derail a hearing. He's protecting the process, because once litigants start attacking each other directly, the hearing collapses. Notice also what he does not do. He does not dismiss her claims. He doesn't accuse her of lying. He simply refocuses. In landlord disputes, judges often have to balance empathy with neutrality. Too much sympathy risks bias. Too much rigidity risks injustice. Here's the deeper question. Is her intensity hurting her credibility, or is it reinforcing how strongly she believes she was wronged?
No, only thing,
No, just go ahead and yell at me. People
Well-
do all day.
well,
Doesn't bother me. I take the robe off, go home. I'm fine.
oh no. But what I'm trying to say, sir, if you look at it, both of them, it seems like somebody whited out. I'm shutting up.
You're not telling me the truth on that. Because you're gonna say so. You're just gonna be quiet for right
I'll
now.
Be quiet.
Okay. All right.
Turn my head. Be quiet.
Miss Dornbush, I don't. You haven't seen these, and
I have not, Your Honor, and just
I'll
giving Ms.
send
Reeves the benefit of not seeing them and that what she's brought to the court is what I think it is. I don't think there's any dispute that Ms. Reeves purchased money orders, but even based on that, there's also no dispute that my client didn't receive that money either. And so I know there's a process.
I absolutely agree with you on both those points, unless, and I don't want to.
What's the name of the roofing company, Your Honor? I do not know a Susanna Vera at the Arbor Woods office. I do not believe that individual is an employee there.
It says LLB Soffit and Gutter Seals, maybe, or.
And Your Honor, if the court's able to scan those over to me, I'm happy to review those.
Yeah,
with
we
the
will.
client.
I
But
was going to do that.
In the interim, I
along
know
with
MoneyGram has a procedure for Ms. Reeves to dispute that the payee is the intended payee and to request that they be reissued to the intended payee. And I don't necessarily have an objection to continuing this court case and having her pay the ongoing charges while those disputed amounts are hopefully reissued by MoneyGram.
Yeah, I don't know if they're, the problem is the last paragraph and you'll see it when it says that they're saying after the purchase of the money order, MoneyGram is not responsible for the acts of purchaser pays and others which may result in a dispute. Confirmation of a cash.
And I think that's for the intended payee. You know, if there's a dispute between the purchaser of the money order, Ms. Reeves, and her intended payee, Arbor Woods. But here, those individuals that cashed those money orders were not her intended payee. Ms. Reeves was certainly not.
No, I agree
Ms.
with you.
Vera or the roofing company.
Well, I'll let you read it. I read what they're trying to say a little bit differently. I thought she was going to be quiet. No, go ahead.
Because, sir, she keeps saying that I purchased these money orders.
Hold on. Let me stop you.
Okay.
Okay. Ms. Dornbush is representing her client.
Yeah.
She's not trying to make an accusation necessarily against you. What she said at the very beginning is absolutely true, and it's something I agree with. I believe that both things can be true here. I think you dropped these off. Somebody got them, right? So what you tried to do didn't happen. What the landlord wants is everything paid. That didn't happen.
This is the legal core of the case. Judge Simpson distills it perfectly. Two things can be true at once. She may have dropped off the money orders, and the landlord may not have received them. Intent does not equal completion. In contract and payment law, delivery and receipt are critical. If the funds never reach the landlord's account legally, the rent remains unpaid, even if the tenant acted in good faith. That's painful, but it's procedural reality. Now here's the strategic move. The judge adjourns rather than ruling immediately. That buys time. It allows investigation. It prevents a potentially wrongful eviction. That's judicial restraint, and it matters. Would you rather a fast decision or a careful one that protects both sides?
That's really all she said. They didn't get the money. and it didn't go to your account. Okay? All right. Did that calm you down at all?
No.
Okay. That's all I got. Can we scan those to be
Because
stored? Yes, ma'am.
if you look at it, it looked like someone whited out.
No, I see what I see what you're saying. The problem is, I don't know. You may be saying that it may be somebody that's affiliated with the landlord.
It is.
Who?
I can't say her name because she was the only one working up in the office. Here I am.
Okay.
I've been putting my
hold on. All right.
Your Honor, if Miss Reeves has a belief on who it is, I would request that she provide me that information so I can discuss it with my client. But as of now, I have no reason to believe that an Arborwoods employee took her money.
She doesn't even work there no more. Her name is Zoe.
Okay, hold on. Just here's what I want you to do.
What?
Okay. First thing I want you to do is you got to take your mother's advice. You need to calm down.
This moment is about control, not over the case, but over behavior. Judge Simpson is protecting fairness. He instructs her to contact opposing counsel respectfully. That's crucial. In litigation, cooperation between parties can sometimes resolve disputes faster than rulings can. If MoneyGram can reissue funds, or if internal investigation reveals misapplication, the eviction may evaporate. But the judge makes one thing clear: disrespect will not be tolerated. That's courtroom governance. He also acknowledges something subtle. Even after investigation, there may be no clean answer. And that uncertainty is terrifying for a tenant facing housing instability. This case isn't just about receipts. It's about whether procedural gaps can cost someone their home.
Seriously.
I'm about to have a heart attack.
Yeah, I know.
Oh
But that's
my
nothing
God.
you're doing because you need to calm down. There's not much that can be resolved. I'm going to put this over a week. What I want you to do so that somebody's name isn't up there, I want you to call Ms. Dornbush's office.
Call whose office?
The
This
attorney's
lady's office?
Yes.
I don't have her number.
Okay, it's on your paperwork. We'll get you a number.
Thank you.
Call her.
Yeah.
And ma'am, I'm just gonna say this. She's willing to take the name. She may not be able to get to an answer.
Mhm.
Okay. Even after she talks to her client, she may not be able to get to an answer. But one of the things that I expect from all people is that you treat people with respect.
Yeah.
So when you call her, I don't want any of this.
Yeah.
If I get a report of any of this, I am not going to be happy.
I know.
She wants to take that. She doesn't even have to do that.
No,
quite
she
frankly.
doesn't.
She has offered to do that so she can talk it over with her clients
Okay.
about it. Okay.
Okay.
So you treat her right. You
I will. I will.
And I know that she will treat you right.
I will. I
Okay. Yeah, that doesn't mean that people have to disagree.
Yeah. Can I say something else?
I cannot stop you. I haven't been able to stop you yet. Yeah, go ahead.
If you look at my pay log, I have never been late for my rent.
That is about the 20th time you have told me that
I know.
between the times you've been here.
I know.
Everybody can see that.
Okay, Judge Simpson. My mama told me to just behave myself in here today.
And do you think you did that?
Yeah.
No.
Okay.
January 31st, 2025. What time? 1 p.m.
1 p.m. Okay.
I'll be waiting with bells on.
Okay.
All right.
Okay. Am I gonna leave those papers here?
Oh, did you make me a copy? Or did you give me back?
I gave.
You back the original, but I have scanned the copy. I can print and file.
Okay. Let's get those back.
Thank you. I'm nervous.
You're nervous?
Yeah.
I couldn't tell. All right. You have a good weekend.
You too, Judge
right.
Simpson. And I look forward to seeing you on the 31st.
This hearing ends not with a ruling, but with a reset. January 31st becomes the next checkpoint. The judge gives time for documentation, communication, and verification. Professionally speaking, this was a measured judicial approach. Judge Simpson acknowledged both sides: the landlord's right to payment and the tenant's claim of misdirected funds. No snap judgments, no immediate eviction. The broader implication: payment disputes involving money orders can become legal gray zones when documentation is altered or mishandled. Tenants should always retain copies and track instruments. Landlords must maintain tight internal controls, especially during staffing changes. As of this hearing, no eviction was granted. The issue remains unresolved pending further evidence. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.